What is a living will? A living will is an important document that every adult should have. It is a legal document that spells out the wishes of the individual in advance regarding end-of-life medical care. The purpose of a living will is to provide guidance for medical professionals and family members when a person is no longer able to make decisions about their own medical care. A living will can be used to provide instructions about treatments that should be continued or discontinued, and it also gives direction as to who should be consulted about medical decisions if the patient is unable to do so. It is an important document for anyone 18 years or older, regardless of whether they have an existing health condition or not. A living will is different from a last will and testament, which is a document used to state what should happen with a person's property and assets after they pass away. A living will is a document used to state what medical care should take place if the individual is incapacitated. Different types of living wills. A living will is a document that allows you to establish your desires for medical care should you be unable to make decisions regarding your health due to an illness or injury. There are many different types of living wills available, which are designed to meet different needs. The most common type of living will is a healthcare power of attorney. This document allows you to appoint someone to make decisions on your behalf in the event that you become incapacitated. You can choose what kind of decisions they will have the authority to make, such as whether or not to terminate life support if necessary. Another type of living will is a directive to physicians. This document establishes your wishes regarding medical procedures, such as whether or not you want to be resuscitated if your heart stops, or if you wish to be given a certain type of pain medication. A directive to physicians can also specify what kinds of treatments and interventions you would prefer if you are terminally ill. Finally, some people may choose to create a living will that covers both healthcare power of attorney and directives to physicians. This type of living will allows you to establish all of your preferences regarding medical care in one single document. Benefits of having a living will. Having a living will is an important document that can have life-changing consequences. It is a legal document that outlines one's end-of-life wishes when faced with a terminal or serious medical situation. Creating a living will is beneficial and important for everyone regardless of age or current health. Below are the top benefits of having a living will. Medical benefits. A living will legally documents a person's wishes regarding their medical care in the event of a terminal or serious medical condition. This can help to provide peace of mind to those facing difficult medical decisions. Knowing a person's wishes ahead of time can also help to reduce tension amongst family, friends, and loved ones. A living will also helps to ensure that a person's medical team will follow the preferences outlined in the living will. This can be especially important when deciding how to handle end-of-life care. Financial benefits. Having a living will can help to view estate planning in a more positive light. By creating a living will, a person can avoid long and expensive legal battles over estate distribution after death. This particular benefit is especially useful for people who don't have a designated heir or for those who want to leave money to specific people or charities. Legal advantages. Finally, creating a living will can provide legal protection. The wishes outlined in the living will are legally binding and must be respected. Without a living will, a court may have to intervene and make decisions about a person's medical care or estate if they become incapacitated or die. A living will helps to prevent this from happening. Who should create a living will? A living will is a document that states one's wishes for medical care. It can be incredibly helpful for anyone who wants to make sure their healthcare wishes are followed in the event of an unexpected medical emergency. But there are certain circumstances where having a living will can be even more important. People in the following situations should consider creating a living will. Adults of any age. Young adults who do not have sufficient mental capacity or are not able to give consent for medical care. Parents of young children. Elderly individuals. People with chronic health conditions. People with life-threatening illnesses. Creating a living will can provide peace of mind, knowing that your healthcare preferences and values will be honored should you ever be unable to express them yourself. Preparing to create a living will. Creating a living will is an important part of taking control of your healthcare before potential end-of-life situations arise. It is crucial to be well-informed and prepared to make this decision before you officially create one. Before drafting a living will, here are a few steps you should take. Gather information on the laws and regulations in your state related to living wills. Research different scenarios that would or would not require a living will. Consult with your family or close friends to understand how they feel about the decision. Reach out to experts, such as medical professionals or attorneys, to help you make an informed decision. In addition to these steps, it is important to record all the decisions made both confidently and in writing so that there is no confusion. Doing this allows you to specify exactly what type of care and treatment is desired in the future. After you feel comfortable with the concept of a living will, you can begin the process of creating and legally notarizing one. Steps to creating a living will. Making a living will is an important step to ensuring that your wishes are honored if you become unable to communicate them yourself. It's a document that states what kind of medical treatment and care you want in the event that you're ever unable to make medical decisions for yourself. These are the steps that you need to take to create a living will. Educate yourself about the types of living wills and legal requirements in your state. Consult with your doctor about your options. Gather information about your medical history, conditions, and wishes. Choose which type of living will best meets your needs. Fill out and execute the living will document. Make copies of the living will for yourself and your family. Have a notary public witness your signature and certify it. It is important to understand that a living will is an advance directive and is not a substitute for a healthcare power of attorney, which gives another person the right to make decisions on your behalf. If you wish, you can include this in your living will. How to sign and have a living will notarized. Having a living will notarized is an important step in the process of creating a formal, legally binding document. A notary public is an official witness to the signing of the document and helps to ensure that the document is properly authenticated. Here are the steps to take to sign and have your living will notarized. Find a notary public. A notary public is a public official authorized by the state to certify documents. Notaries can usually be found at financial institutions, law offices, and other businesses. It's important to make sure that the notary you choose is authorized in your state. Make sure all the necessary parties are present. Typically, this requires that the person creating the living will, the principal, and 2 witnesses must be present. The witnesses must be 18 or older and not directly related to the principal. The witnesses must also understand what they are witnessing and be willing to sign the document. The notary will ask all parties involved to present government-issued photo ID. This helps to protect against fraud and establish that everyone who signs the document is who they say they are. The notary will administer an oath to the principal that the document is a true copy of the original document that was signed. Once the living will is signed, the notary will affix their notary seal to the document, making it legally binding. Once the document is notarized, it will be sent to the appropriate state office for filing. It's important to keep in mind that some states have different requirements for having a living will notarized. Make sure to review the laws in your state so that the process goes smoothly. Thank you for watching. Don't forget to hit that subscribe button and ring the notification bell so you never miss an episode of Caregiver Relief.